to address the court. But anyway, for the record, this is 25T448, 25M352, 25M395, 25M375, 25M318. All people v. Joseph Shadowins, who appears in person in the courtroom. Mr. McKissick from the District Attorney's Office appears in person as well. You're standing. So Mr. McKissick?
Yes, so I was able to speak with the defendant a little bit about kind of the 5 cases coming up. It doesn't appear that we'd be able to reach a resolution, considering some of the things that I would have pointed to as direction for the defendant doesn't seem like something that they would be willing or able to do. This would include picking up one of their issues that they haven't been given any discovery on any of these cases. I let the defendant know that I myself do not give or take in discovery. That's something that can be asked for from the district attorney's office by going there physically and then asking for the discovery, which would be handed over at that time. The defendant let me know that that would not be possible for them, that he was told that if he were to go to the district attorney's office, that he would be arrested. It's not typically something that the district attorney's office would impose a arrest for someone coming to pick up discovery without some other maybe factors that haven't been mentioned. So I'm kind of at an impasse as to what to do. It seems like many of the asks by the defendant is not something that I can readily take care of, even though that would be a simple solution, is just going down to the DA's office and getting up discovery. But moreover, he's asked me to take some of his own evidence, which is not something that I was willing to take at this time. I think from a procedural posture in this case, we're once again at an impasse. I think the defendant claims that they're not a sovereign citizen, even though many of their arguments align fully in place with many arguments that I've seen from sovereign citizens. He's asking for a change of venue to a basically a court that we don't have in the state, common law court. So like I explained to them, this precedent that they're brought up is kind of their argument, or perhaps their defense. It's not a valid argument, and there's nothing that I can do as a prosecutor to have the case moved to a court that doesn't exist, essentially.
Before we jump into this hearing, let me set the stage, because what you're about to see is one of the most textbook, and unintentionally hilarious, courtroom contradictions you'll ever witness. Today's case takes us to Colorado, where a man stands before the court insisting he is absolutely not a sovereign citizen, while simultaneously using almost every sovereign citizen argument ever invented. And that's not an exaggeration. We've got multiple cases bundled together, a frustrated prosecutor, a judge who has clearly seen this movie before, and a defendant who believes paperwork, special appearances, and status corrections somehow override reality. The tension here isn't just legal, it's ideological. This defendant believes the system has wronged him, while the court is trying to operate within basic procedure. And here's the twist: the more he insists he's not a sovereign citizen, the deeper he sinks into sovereign citizen logic. Common law courts that don't exist. Discovery demands that ignore procedure. And an absolute refusal to engage with the system, while conspiracy collide in a courtroom, and it only gets more unhinged.
It's position that many of the claims and statements I make are in alignment with that. I have clearly corrected my status as de jure on and forward Teller County records that this court has admitted they haven't read. I have filed motions to dismiss many of these cases based on those records, and the subsequent motion to dismiss, Your Honor admits on record she has not read and denied. So I am not aware of any victim. The evidence I was trying to give the state this morning with respect to an alleged victim are rebuttals to affiance. So I do not qualify for an attorney. I cannot afford an attorney due to damages from the state, nor can the state provide a common law a defense with the assumption that I am a domestic terrorist. That is a clear conflict of interest. Your Honor herself has admitted multiple times on record in multiple cases, calling me a sovereign citizen, refusing to answer my questions, dismissing them as sovereignty arguments, and so on and so forth. This is clearly due process issues, clearly conflict of interest issues. And I cannot plea or proceed without full discovery of facts, evidence, and elements. There are also issues on the docket today that Miss Hudgens' name is under. I have never consented to an attorney. I have no discovery. I have no complaints. I have not even basic discovery. So how can I defend myself if I can't speedily rebut claims?
Okay, so thank you, Mr. Shadowins. So what I'm hearing is there's an issue about discovery. You know the process to get the discovery, which is to go to their office in Colorado Springs. They have a discovery, apparently some kind of office. And you can obtain all the discovery in these cases. If you hire an attorney, that attorney could also go and request that discovery. And what's the problem with that, sir?
I have receipts. I have emails from DA's office saying, "Do not come here. We will arrest you."
Where are they, sir?
I wasn't prepared to make that argument. I tried to give evidence of rebutting of affidavits today. Prosecution won't take it. Non-response from the DA's office times 2 prosecutors.
Stop, let's
You-
stop.
allow me
I'm
to
trying
speak, please.
I'm trying
Please
to
do not
get,
rush justice.
can we get
I'm
an
trying to answer
answer?
your question.
Well, I hear that you're saying that you don't have anything
I don't have it
from,
with me today,
okay.
but I have emails to multiple prosecutors plus Ms. Schaaf, senior investigator, requesting discovery disclosure of evidence. I was told I could go to the police station to pick it up, denying the fact that I have restraining orders from multiple police officers for whistleblowing. Okay, I can't go to pick it up in person because cops took my truck. That was the principal issue leading to all of these cases, a driving versus traveling issue deemed sovereign citizen arguments. I have never been a sovereign citizen. I have common law standing on file with the county, and
The calm before the storm. The prosecutor is doing something very important, and very understated. He's documenting the impasse. He's explaining, clearly and professionally, that there is a lawful way to get discovery, that it's been explained to the defendant, and that the defendant simply refuses to engage with it. This is critical because sovereign citizen-style defenses often rely on creating procedural chaos and then blaming the court for it. Notice how the prosecutor even acknowledges the defendant's concerns, but points out that none of them prevent lawful access to discovery. That matters. Also listen closely to the phrase, "arguments I've seen from sovereign citizens." That's not an insult, that's a legal classification. Courts across the country recognize these arguments be.
At this point, Mr. Shadowins, that your arguments do align with sovereign citizen arguments.
Object, personal opinion bias.
I get you. So it looks like you have someone here who perhaps could take you to the district attorney's office in Colorado Springs, although I know because of your past failures to appear, he's had to post bonds, and I think he had some questions about that.
Yes, do I have clearance to not be arrested if I go and try to petition for discovery? I do not wish to motion for discovery with jurisdiction issues raised by the state not affording me the opportunity to rebut. The state twice raised the issue of jurisdiction, and I was not afforded a rebuttal. These affidavits clearly rebutted, and there's no notary present in the court today. Mr. Kissick will not allow me to submit evidence in my defense.
So, the thing also, Mr. Shadowins, is it's very confusing to follow your arguments.
That's because I'm common law and you don't recognize that. which is the bias and conflict of interest.
That is absurd. That is an absurd argument, Mr. Shadowins, and I will not.
Objection, personal opinion.
Thank you.
Fine.
I have made my ruling. It's absurd. So here's what I would, I did, and I will say that I did read the documents that you did file, Mr. Shadowins. Even though your handwriting is not easy for me, I had to, you filed, the last thing that you filed, your motion to dismiss was filed on the day of your last court appearance, and I did not have the time to look at that beforehand.
Motion to reconsider?
Okay. That makes no sense. Haven't ruled. You only asked to reconsider if I've already ruled.
You
I
dismissed my
Here's-
motion.
I have not,
You dismissed my
told you.
motion to dismiss based saying that you hadn't read it. I take no
This
action.
is where the mask slips almost immediately. The defendant opens by saying he's appearing by special appearance, which is sovereign citizen language. He then says he's not a sovereign citizen, but agrees that everything he says aligns with sovereign citizen arguments. That alone is a contradiction. Then we get, corrected my status, de jure, and county records, all phrases rooted in the belief that legal status can be altered by paperwork rather than law. That's not how courts work. Legal status is determined by statute and jurisdiction, not by filing documents that declare sovereignty. He also accuses the judge of not reading motions and claims bias, a common escalation tactic. When sovereign citizen arguments fail legally, the next step is often to accuse the system of corruption or conspiracy. This isn't confusion. This is a belief system colliding with reality. And the court hasn't even pushed back yet.
Through your motion for dismissal, Mr. Shadowins, and in regard to due process of law, there's really no clarity about what specifically you're concerned about, but you have, as far as due process rights to be heard and to, let's see, to understand, well, to be heard and to have really, it says no one shall be condemned without an opportunity to be heard. So you have had the opportunity to be heard. You've appeared in court. There is no violation of due process of law. In regard to the Sixth Amendment, also I will find, as far as due process of law, if your concern is about the statute, the court is, there's nothing specifically about any of the statutes of which you're alleged to have violated, which you've not said they're not sufficiently clear to persons of ordinary intelligence to afford a practical guide for law-abiding behavior and capable of even-handed enforcement. All the statutes in these cases that have been charged as violations against you, court does find that they are sufficiently clear to persons of ordinary intelligence and they are capable of even-handed enforcement.
I don't even
In
know
regard,
what that means, Your Honor.
wait,
I'm
I'm responding to you raise these issues. You write due process of law with no real explanation. I have to make assumptions about what that means.
Objection, the court would not hear it.
In Sixth Amendment,
Dismissing it as sovereignty arguments, end
I
quote.
have not dismissed. I am ruling right now,
You
Mr.
can't rule, you haven't heard the
Mr.
matter.
Shadowins, I did read your motion and I am ruling right now, so be quiet. In regard to the Sixth Amendment, that the Sixth Amendment provides for speedy public trial by an impartial jury, informed that you be informed of the nature and cause of your accusations, that you are confronted by witnesses against you, have a right to subpoena witnesses and right to counsel. You have all of those rights. None have been denied to you. In regard to obstruction of justice, there's no, the court denies that or dismisses that argument. There's no specifics. It just simply says obstruction of justice. Prosecutors refusing to respond with discovery, court denies that. Court notes that the district attorney has provided information how Mr. Shadowens can obtain that discovery. In regard to state can't be an injured party, the state does file the cases to enforce public laws and publish violators. The primary goal of the state is to ensure justice for the community, not just a specific individual's loss. So that is.
This section is incredibly important for viewers to understand, because it's where many people get misled. Discovery is not optional, secret, or arbitrary. Courts have established processes for it, and those processes apply to everyone, whether you trust the system or not. The defendant claims he can't get discovery because he believes he'll be arrested if he goes to the DA's office. But notice something crucial: there is no evidence presented. No emails. No documents. Just assertions. Courts operate on evidence, not fear or speculation. That he also claims restraining orders from police officers and says his truck was taken, but again, none of that legally prevents discovery. What we're seeing is a pattern: refusing lawful options, then claiming victimhood because the court won't invent new ones. This is where many defendants self-sabotage. The system gives them a door, and they refuse to walk through it.
Always file that, Mr. Shadow.
I did. It's on file.
All right. I have ruled that, that nothing about the state, the fact that all your cases are the state of Colorado versus you, does not prevent those cases from proceeding forward. Those cases will continue. In regard to change of venue, there's no reason under Rule 21A of the Colorado Rules of Criminal Procedure to find that you would not be able to obtain a fair or expeditious trial in Teller County. So I deny that request at this time. If you wish to submit some additional information about why you think there should be a change of venue under Rule 21, you should follow the rules there.
I do. It's
The
right here. I'd like to read it for the record, please.
Irrevocable trust is an absurd argument. Traveling, not driving. I did rule on the record in this on that issue before. In People v. Zen, the right to drive a car on public roads is not a fundamental right. States do have the right to regulate the use of motor vehicles on roads in this state.
Prove up the claim of a
so
contract of a valid driver's license.
So that argument regarding traveling, not driving, is denied. Impossibility to obtain your driver's license. I have no authority over the Department of Motor Vehicles. That's something you will have to deal with the Department of Motor Vehicles about. You have been in this courtroom all morning and heard different people talk about their efforts to obtain their driver's license. You can certainly get that information from the Department of Motor Vehicles. In regard to WebEx authorization, you are authorized to appear by WebEx, and you have appeared by WebEx on the last court date. Again, you raise the same issue regarding discovery. I have already advised you that you...
The defendant opens by saying he's appearing by special appearance, which is sovereign citizen language. He then says he's not a sovereign citizen, but agrees that everything he says aligns with sovereign citizen arguments. That alone is a contradiction. Then we get, corrected my status, de jure, and county records, all phrases rooted in the belief that legal status can be altered by paperwork rather than law. That's not how courts work. Legal status is determined by statute and jurisdiction, not by filing documents that declare sovereignty. He also accuses the judge of not reading motions and claims bias, a common escalation tactic. When sovereign citizen arguments fail legally, the next step is often to accuse the system of corruption or conspiracy. This isn't confusion. This is a belief system